Welcome and thank you for joining us today for our Land Services SA webinar on leases and underleases. This is a pre-recorded session with a live Q&A session at the end of the presentation. We ask you to kindly hold all your questions until the allocated time, where our subject matter experts will be able to assist. Land Services SA is committed to providing an excellent customer experience. One way we continue to deliver value to the industry is through our industry education program, where we produce a range of helpful educational materials, hold regular webinars, and host industry events. Our industry education program addresses key topics or frequently asked questions to ensure you remain up to date with contemporary practices. We want to help set you up for success and believe helping with industry education will help reduce the volume of requisitions, meaning a quicker and more seamless experience for your clients. Land Services SA subject matter experts assist in delivering our industry education program, utilising their years of experience and respected place in the industry. This presentation has been prepared by Natasha Stupel, the Registration, Training, Audit and Workflow Officer for Land Services SA. Natasha has been working in land titling for over 35 years and has an extensive background in the examination and registration of paper and electronic dealings. This session will be covering mandatory electronic lodgement, lease land description where no rights are being created, lease land description where rights are being created, lease the estate and interest panel, underlease land description, lease and underlease party panels, lease and underlease term, lease and underlease operative clause, lease and underlease consents, and lease and underlease date and certifications. Let's begin. Both leases and underleases are mandated electronic lodgements and should be prepared and lodged electronically. At this date, the only electronic lodgement network operator that supports the electronic lodgement of leases and underleases in South Australia is PEXA. Current exemptions for all mandated dealings can be located on Land Services SA's electronic conveyancing page on our website. It is important to note prior to your lease preparation that when contiguous allotments of land held by different registered proprietors in separate certificates of title are to be leased to the one lessee, separate leases should be prepared. Refer to Notice to Lodging Party number 120 and note that this type of dealing is not an automatic exemption to mandatory electronic lodgement, as the preparation of two separate leases has been strongly encouraged since 1998. The remainder of today's presentation will focus on the requirements for each panel for leases and underleases, and we will work through these panels in the same order as the lodge form as closely as possible. Where whole or portion of the land in a certificate of title is being leased and no rights are being created, the description of the land is shown in the first panel of the dealing, headed Land Description. There are two options for the Land Description panel: whole of the land in a certificate or certificates of title, or portion of the land in a certificate or certificates of title. Any portion to be leased or underleased must be uniquely identified in a plan already deposited with this office or a plan attached to a prior registered lease. This is detailed in Notice to Lodging Party number 146. The plan does not have to be a plan specifically for lease purposes. Any portion identified in an existing plan deposited in the Lands Titles Office can be utilised for the lease and underlease land description. The Registrar General's notes appearing at the bottom of a register search or check search displays a list of plans that have been deposited as regards the land contained in the certificate of title, and is a good starting point to check for existing plans when preparing your dealings. Where it is intended that the grant of lease is also to include the creation of rights, the description in the first panel of the dealing, marked 1 on this slide, should be the whole of the land in the certificate of title. The description of the portion of land being leased and the rights being included or created are to be shown in the panel marked 2, headed Define the land being leased incorporating the required easements. It is important to note that portion of land leases, together with rights over appurtenant land and adjoining property, will not be accepted for registration. Leases for easement purposes of limited duration will require the lodgement of a TG2. It's also important to note that rights cannot be created in an underlease. The estate and interest panel for a lease is to be completed with fee simple for a lease over land contained in a certificate of title, or Crown lessee if the land being leased is contained in a Crown lease. For an underlease, this panel is not present and not required. A lease or underlease of a Crown lease will require the Minister's consent, and this must be attached to the dealing at the time of lodgement. The panel marked 1, headed Lease being underleased, should describe the head lease that is being underleased, and the registered number of the relevant head lease should appear in this panel. If the head lease is unregistered or lodged in series with the underlease, the head lease should be described by its date and the parties to the dealing. That is, lease dated between, name the parties, and lodged contemporaneously herewith. Panel Mark 2 is headed Land Description. The function of the Land Description panel is to identify the precise area which will be subject to the underlease. To underlease portion of the land in the head lease, which is also portion of the land in the CT, the portion must be uniquely identified in a plan deposited with this office. An underlease may be granted in respect of either the whole or portion of the land in the head lease. This is to be indicated in panel 3, headed whole/part. For example, a management firm leases the entire shopping centre, being whole of the land in the CT. The management firm now wishes to underlease one shop in the shopping centre to a pharmacy. The underlease land description, panel 2, will describe portion of the land in CT and include the description of the portion being underleased as per a plan deposited in this office, and the panel mark 3 will state part. When a lease is registered as regards the whole of the land in 2 or more CTs, and only one is being underleased, the land description in panel 2 would be whole of the land in CT, and panel 3 would be part. Both the lessor and underlessor panels should disclose the full name and current addresses of the parties. If the lessor or underlessor are registered incorrectly or have changed their name, an application to note change or correction of name should be lodged prior to the lease or underlease. The lessee and underlessee panels should refer to the full names, addresses, and the mode of holding for incoming parties. As with all Real Property Act dealings, no reference to trust should be made in any of the panels. The term of the lease must be certain or capable of being rendered certain before or at its commencement. If the lease contains a right of renewal, this should be inserted in the same panel below the commencement and expiry dates. The term of an underlease cannot be longer than the head lease, or the residue of the term of the head lease. That is, the underlease cannot expire at either the same time as the head lease or subsequent to the determination of the head lease. This example shows that the underlease expires 1 day prior to the lease term, ensuring that the term of underlease is no longer than the term of the head lease. An underlease that is certain to absorb the residue of the head lease's term will not be registered. The Rent and Manner of Payment panel is a free text panel and should describe the information relevant to the rent amount and payment detail for the lease or underlease. The Covenants panel will refer to the annexed or uploaded covenant pages along the lines of this example. It is also acceptable to refer to a deposited standard terms and conditions of lease by inserting the deposited dealing number. The operative clause is set wording with a selection/deletion option to reflect whether the covenants have been attached or are contained in a deposited standard terms and conditions. Where a deposited standard terms and conditions is referenced, the deposited number should be included. The selection/deletion option of wording in this panel should reflect the wording previously inserted in the Covenants panel. Consents can be prepared and executed in the existing panel or on an annexure for both paper and electronically lodged dealings. Most leases and underleases should be lodged electronically, and consents will be uploaded as an attachment. Consents for both leases and underleases are optional. However, it is important to be aware of Section 118 of the Real Property Act, which relates to leases not being binding as regards non-consenting mortgagees or encumbrancees. The following principles apply to the completion of the consents panel. The consenting party should be named, its address is optional, and if it is a company or a registrable Australian body, its ACN, ARBN, or ABN should be included. The capacity of the party should be identified, for example, the mortgagee pursuant to Memorandum of Mortgage Number. A statement should be included to the effect that the party consents to the lease or underlease. The party should execute in the ordinary manner, and if the party is a natural person, his or her signature should be witnessed. However, compliance with the attestation requirements provided for in Section 267 of the Real Property Act is not insisted upon. Typically, for an underlease, the consents that are to be inserted are those of the head lessor and any prior registered mortgagee or encumbrancy. However, as with leases, consents for underleases are not insisted upon. Where no consents are being attached, please insert "Not applicable." As with every dealing, the date of the document must be completed prior to lodgement. Certifications are required for the lessor and lessee for a lease, and the underlessor and underlessee for an underlease. If either party are self-represented individuals, the first two certification statements should be deleted, and verification of identity and verification of authority requirements must be produced with the paper lodgement of the dealing. Land Services SA's website has a range of educational and support materials to assist you in your day-to-day work. Our Industry Education Hub is a good place to start. This can be found by clicking Industry Education Hub on the homepage of LSSA's website. A copy of today's webinar will be published on the Industry Education Hub together with recordings of previously held webinars. That concludes the recorded webinar section. Thank you for listening. Please remain online for the live Q&A session with our subject matter experts.